Roberts.
Thank you, Chair, and thank you all for attending. Ms Parker, could you tell me briefly your role, please? What's the core of your role?
Senator, I'm a statutory appointment, independent statutory appointment, and I'm responsible for the functions, implementing the functions under the Fair Work Act. So that includes providing education, assistance, advice and guidance to employers, employees, outworkers, outwork entities and organisations. Secondly, promoting and monitoring compliance with workplace laws. Thirdly, inquiring into and investigating breaches of the Fair Work Act. 4, taking appropriate enforcement action. And the last one is to perform the agency statutory functions efficiently, effectively, economically and ethically. So the Fair Work Ombudsman, as in myself, inspectors and staff constitute a statutory office established by the Fair Work Act 2009, Senator.
Thank you very much. This so-called casual, and I say so-called in reference to they're not really casuals, they're permanents that I'm referring to in the Hunter Valley in particular, but there are some aspects that translate into Queensland, so we're very concerned about that. But this so-called casuals coal miner issue has dragged on for years. What are you doing to fix this problem?
So, Senator, we have, we're well aware of your issues, and we've had, as you know, we and I have written to each other a couple of times, and we take the matter really seriously. So I can assure you of that. Where it's about long service leave, I think we've mentioned before that there is a coal mining industry long service leave funding corporation. Mm-hmm. And we don't have anything to do with that. So long service leave is not our purview. And we do provide basic information around that, but we do refer specific inquiries to that corporation if it's on long service leave. The Fair Work Commission, who you spoke with earlier, they have jurisdiction to resolve long service leave disputes under the Coal Mining Industry Long Service Leave Administration Act. And the Fair Work Commission can assist with disputes under the Act as well, when a modern award provides for a procedure to deal with disputes. So we don't have power of that kind. We can provide general information about the long service leave scheme in the black coal mining industry. So we're aware of a number of class actions that are being pursued around issues in the coal mining industry. We're obviously watching those, but they are before the court. So I won't be able to comment on those, as you probably can understand, or about the circumstances of any individual who has sought our assistance in regard to the matter that's before the court.
Okay, thank you. You did broaden it by mentioning the coal LSL, so I might as well put the whole scope in there. I know you can only access or reference or work on some of those. Loss of workers' compensation, no accident pay, these are miners in the Hunter Valley. Safety issues, non-reporting of injuries, and as I said, these are not, some of these are beyond your purview. Pay rates, leave, loss of leave entitlements, long service leave you already mentioned, security, threats, intimidation, bullying. Now, as I said, and I'll repeat, they're not all your responsibility, but I'm particularly concerned about the definition of casual mine worker and the award, which, as you know, and your website has said, and in a letter, one of your advisors has said to Simon Turner that there is no classification of casual in the black coal mining industry award. So specifically on pay and leave, there are no leave provisions in the enterprise agreement. These people are working full-time production roles, yet casuals can only work they can't work in production. They're working extended rosters with no leave, and they're being underpaid relative to their peers on full-time employment. And they also have been neglected by the unions. We're very concerned that I'll make that very clear, specific, Hunter Valley branch or Hunter Valley division of the CFMEU, not the whole CFMEU. And these people have no one to turn to. They've turned to you and they've written to you, as I said, and one lady said, there is no classification of casual. So how can they do a boot test when there's nothing to compare against?
So, Senator, we're talking about the enterprise agreement that was negotiated with the unions and employers and approved by the Fair Work Commission.
It was rubber stamped by the Fair Work Commission.
It does include casuals, as you said, in some categories. The fact that the award doesn't have casuals does not preclude the enterprise agreement having casuals. I think Mr Hare said in his evidence that it is the Fair Work Commission's role to make sure that that's fair once the enterprise agreement is agreed.
How then can BHP's operational services recent application for an enterprise agreement be knocked back, and yet the Chandler-McLeod 2015 enterprise agreement be passed, even though the OS pay rates are higher than the Chandler-McLeod pay rates? It's
a matter you'll have to ask the Commission. I'm sorry.
I did.
They are an independent tribunal, and they will have had witnesses in front of them, people providing evidence to them before they made that decision.
Well, I asked the Fair Work Commission about anybody applying to vary the black coal mining industry award about casuals, and they said they're not aware of any. But I notice I think it's from one of your work sites, and certainly one of your websites, and also certainly from the CFMEU in Queensland, that the Fair Work Commission rejected an application to vary the Black Coal Mining Industry Award 2010 to enable the engagement of casuals across all classifications of the award. Now that was an application from a large employer group, and the CFMEU opposed that, and it was defeated. So how would the Fair Work Commission not be aware of that?
Senator, if I recall Ms O'Neill's evidence, it was she didn't believe they had, but that she would take it on notice and check. So I think that's where she went to.
It's pretty stunning, Mr Hare, that this issue has been going on 6 years. We've made such a big fuss about it in the last 12 months, and she wouldn't be aware of that. But anyway, that's for her, as you said. Recently, I asked you, Ms Parker, how many casual black coal miners from the Hunter Valley have referred complaints or matters relating to their pay and entitlements to your office since 2014? Your response was none. And since that time, you've been forced to admit that Mr Simon Turner did lodge complaints during this time period. Can you advise if there were more cases, and in all instances, please advise the outcomes of their complaints?
Senator, we do apologise that we advised none, and we were certainly not trying to hide that. It's in terms of our search facility. You have to be very precise. I mean, this is black coal, and it's a specific area of black coal. So I apologise, and we did correct the record, and we have had one that we're aware of, and we're pretty confident that that's all we have. As I said, we have, the system searches are maybe not as surgical as we would like, but we're very much aware of one.
Well, who is responsible? I take it that the Attorney General's department now and the predecessor of the preceding minister who looked after industrial relations are responsible for changing the regulations or the legislation. Who's responsible for advising them of the need to do so? Because casualisation and the abuse of casuals has really been an issue for quite some time. And yet now it's landed employer groups and many, many hundreds, thousands of workers in problems.
Senator, we, in terms of our role as the ombudsman, we enforce and apply the law as it stands. So, as you say, we're not responsible for the policy or legislation. We haven't changed
I didn't imply that you were responsible for the legislation,
No.
but I would have thought that you could have been advising the Attorney-General or his predecessor of the need to resolve this problem that's been going on now for at least 6 years?
And we certainly have regular conversations with the department
About this issue?
about a whole range of matters.
When did you start talking to them about this issue?
I haven't discussed this particular issue. We've talked about the work pack versus Rosato issue, how we interpret casuals, what advice we provide to the public on casual employees, and we're aware that the government's review of the IR system and the working groups are looking at this area of casual employment, and we're monitoring that, and we'll provide, advice and data. We're happy to share with the committee what we do with the casuals issues or what advice we provide. But in relation to the legislation, that is a matter for the government.
It's my understanding that the Fair Work Ombudsman told Mr Turner to, quote, go get a lawyer in order to, end of quote, in order to resolve this, and that you have denied the existence of casual coal production workers. Are you aware of you are, I hope, aware of the significant damage this stance of yours has caused both employees and employers who now, in taking advantage of this, have racked up a huge liability?
So, Senator, I don't believe that we would advise anybody to go get a lawyer. What we do is we provide advice to people about all the various areas of assistance that are available to them. Where we are unable to help them, as in we do not see that they are eligible for payment based on the definition in the legislation as it stands, we will advise that they may be able to go to small claims, they may be able to take a court case. And in fact, as I mentioned earlier, there is a class action being pursued at the moment on this particular issue.
Have you done anything to actually help Mr Turner and casual employees like him? And why is it taking so long and it's still not resolved? These people are in limbo, they're living out of garages, they've been traumatised. Why?
Senator, we provide ongoing assistance, and we provide assistance to everyone who contacts us. I'd rather not discuss Mr Turner. I mean, we don't talk about specific requests for assistance. We haven't asked Mr Turner if he minds us talking about him in Senate estimates.
Mr Turner has assured me that I can inquire about him.
Yeah, so
he's very distraught about the lack of support he's received from anyone, including the union, the employers, the mine owner, BHP, state and federal bureaucracies and agencies, Labor MPs, Liberal ministers. He's at a loss.
Yeah, so all I can say there is, Senator, we have provided, our website says only staff employees can be casuals under the award, and the web page references Schedule B of the award. It sets out classification for staff employees, etc. We've provided the factual information that we have on the actual award. Some people have not been satisfied with that answer, and so the only option we have is to refer them to those other sources of help, including their ability to go to court if they wish to. We're not a court or a tribunal.
So there's a problem here. Obviously, within the legislation, there's a problem, and some people are taking advantage of that. And you've just said, well, tough. That's the way the legislation is. You haven't referred it to anyone who can change the legislation or investigated changing that or advising changing that. These people are still out in the cold.
Senator, the government's aware of the issues around casuals, and as you know, there is a...
So how long have they been aware of the issue around casuals? Because Mr Turner has been writing to people in the government since 2014.
Senator, it might... and sorry to interrupt, Sandra. I think we've talked broadly around the government's intent to legislate for a definition of a casual and to legislate for casual conversion rights. And I accept that the casual conversion rights may not work at this point in time for the individual you're referring to. The issue that perhaps to be worthwhile us meeting with you separately on is how the enterprise agreement definition has actually impacted on the other issues that you raised. So what I'm not clear about, Senator, is how an enterprise agreement arrangement would impact on somebody's right to workers' compensation. So perhaps if we can meet with you separately to try and tease out how this all flows to end up where the actual problems are arising. So on the face of it, there's nothing to my knowledge that would mean that somebody who has an enterprise agreement isn't entitled to workers' compensation. I'd need to get into more detail to actually understand what's occurring to cause that break.
Well, Ms Parker raised Coal LSL, and when she did, I said, well, let's go to the full scope of how these people are being exploited and abused and neglected. And you've now raised workers' compensation as well. That's not the main issue. The main issue here is that the complete complexity of the issues, and no one is fixing it. Not the state government, not the federal government, no federal or state agency, no politician is fixing this thing. These people are continuing after 6 years of neglect and exploitation to face this. I asked Ms Parker a simple question. How long has the government known about it? Because she said, we know the government knows. I want to know how long they've known about it. Was it last year? Was it the year before? Was it 2014?
I was talking about casuals in general, Senator. I apologise if I confused you.
Well, it's not hard to be confused in this issue, I can tell you, because there are several people who know one thing very, very clearly. They are not being protected by employers, unions, agencies, federal and state, politicians, governments, ministers, at all. These people have been left out in the cold. So we now know there's no legal pay rate for a casual mine worker. So someone made it up then, otherwise you wouldn't be able to do a boot test.
Senator, so that's not the responsibility of Ms Parker. So
well, with respect, Mr Hare, you said it wasn't the Attorney-General's responsibility, and I took it that you implied his predecessor. It wasn't their responsibility. You said, look at the Fair Work Commission. The Fair Work Commission told me it's not their responsibility. Look at the Fair Work Ombudsman. We're getting run around in circles. This is a magic circle, this one.
So, Senator, my understanding of the evidence provided by Ms O'Neill was that in assessing the the enterprise agreement that you referred to, that the relevant commissioner under the legislation would be required to assess whether that award was better off overall compared...
I get that, but how can you refer to a rate when there's no rate?
So, Senator...
And I offered her the opportunity of giving her the full-time roster that these people are employed on as casuals. Could you cost that?
So, Senator, it's a very complex process that the Fair Work Commission undertake to make sure that people are better off overall. I think Ms O'Neill's evidence was that they've changed their practices to try and insert more rigour into that.
But that indicates that there was a problem before the change in 2016.
It certainly indicates...
Sorry, last year. So what is going to be done to look after the people who were affected by the unrigorous system?
So, as I said, Senator, you've raised a number of issues and circumstances around this particular individual, and you say others, which...
Hundreds of others.
So, as I said, it'd be useful if we could meet to go through the relevant issues. As I said, there are some of the things that you imply arise from the enterprise agreement definition. I'm not clear how they would cause that, so I need to work through that and understand the interaction with the New South Wales workers' compensation laws. There's separate work occurring around the long service leave, but certainly I'm not aware of a circumstances in which the arrangements for under an enterprise agreement would impact on workers' compensation. So I'd need to have a look at that. In terms of the actual decision, I think Ms O'Neill was clear. If someone didn't think that decision was appropriate or that enterprise agreement was correctly decided in terms of passing the boot, they were able to appeal it. Now, I think Ms O'Neill identified that that particular enterprise agreement has nominally expired, and that the other option that you've got there is for someone to apply for the agreement to be terminated. They are the technical processes that need to be followed. As I said, there seems to be a complex web of interactions here. It would be useful if perhaps we could meet with you to go through those.
I'm happy to meet privately with you and go through them, but we've had several meetings and nothing has happened. What's my main concern, Mr Hare?
Senator, your main concern seems to be that the individual is stuck in limbo
And hundreds of others like him.
And that he cannot find a straightforward answer from the Commonwealth Government or the state government.
He's wanting more than an answer. He and I are wanting a solution. I've got 3 aims for this, and I've said this from the start. This goes back to May last year, and I first raised it around about July last year, and then Senate estimates and so on. My 3 aims are, first of all, to make sure that Simon Turner and other people like him get their fair entitlements, morally fair as well as lawfully fair. And I want him to get some compensation for the trauma he suffered for the last 6 years. Second aim is to make sure these practices are stopped right across the coal industry. And the third aim is to bring some justice to the perpetrators of this, who, in my opinion, are BHP, Chandler McLeod and the Hunter Valley division of the CFMEU. That's what I want. Is there any way you can help us in achieving some of those 3 aims?
Senator, we can certainly look at what the legal entitlements are. In terms of the moral entitlements, I'm not sure exactly what you mean by that. The legal entitlements we can certainly examine.
I mean, if you go beyond the nitpicky words of the law and you look to the intent of the law, he's being diddled by some mistakes, some ways of interpreting the law wrongly. Everyone knows that a miner who works in a black coal mine is entitled to workers' compensation under coal mines insurance and accident pay. Nothing for him. I'm not going to ask you your salary, but he's existing on $20,000 a year, a fraction of what he used to have.
Yes, Senator. As I said, I'm not aware of what his enterprise agreement status would have as an impact on his workers' compensation. What I've offered is to meet with you to go through the details to try and understand how that flows.
I'll happily agree to that. But my second complaint is that, or problem, my second concern is that this has been going on unresolved for 16 months now, and I don't see any sign of it being resolved. And these people are still being left out in the limbo. They've just been discarded. My concern now has become, what are the federal government agencies doing? And is the government at all interested in doing this? How can we possibly support changes to legislation when they're not even enforcing the current legislation or leaving people out in the cold? And there doesn't seem to be any intent or desire to fix it.
Certainly, that's not my understanding of the attorney's view. So, as I said, I'm happy to meet to go through the detail. I know that there's work underway in relation to long service leave, which was the issue that
after first being denied that there was an issue and then admitting it, that's a pleasant sign. Took us months to get that.
Senator, so as I said, there is work underway to try and resolve the long service leave issue. In relation to the actual approach around the enterprise agreement, as I said, I'm happy to have a look at the interaction with other matters, but the enterprise agreement was a document that was accepted by the Fair Work Commission once the employees had voted on it.
After what we now see, Mr Hare, an admission that it's been tightened up and made rigorous, which implies to me before that it wasn't. So there's
think
been
Ms. O'Neill-
no investigation of that, from what it seems.
Ms O'Neill, I think, was at pains to point out that she wasn't making the statement that the previous process had caused any issues with that particular agreement.
But there were changes to make it more rigorous, so implying that it wasn't as rigorous before. So what I'm seeing, Mr Hare, is that the Fair Work Ombudsman is not taking responsibility for suggesting changes to a problem or solutions, or even identifying the need to investigate a problem to the Attorney-General. And I'm also seeing that it's not the Fair Work Ombudsman's responsibility to come up with a solution. So how does the Attorney-General possibly identify this? This just sits there and Simon Turner keeps sleeping in a garage.
So, as I said, Senator, the responsibility for the actual awards and then the approval of the agreements is the responsibility of the Fair Work Commission. Ms O'Neill's outlined what she believes are the alternatives there and taken some questions on notice. In relation to the issue around whether Mr Turner was a genuine casual or whether he was actually should have been classified as an ongoing employee, the attorney has identified that he intends to introduce legislation this calendar year to deal with the definition of a casual, to try and stop, to make it clearer for people, both employers and employees, what their actual status is, and to also to provide greater clarity and certainty around the right to convert. So in terms of the future, that particular aspect is certainly being looked at. And as I said, the interactions with the other jurisdictions I'd need to have a look at.
Right, I'm concerned that Rosado, the application that the government has submitted to be part of the Rosado case, I don't know the technical term, the legal term, but join the case, was accompanied by some pretty inflammatory rhetoric. All I see in the Rosado case is a decision that says you tried to have these people passed off as casuals, they're really permanents. And so I think we need to have a lot more openness and candour and honesty from the government on Rosado.
So, as I said earlier, the government's primary interest in Rosado is clarifying whether the loading that's provided to casuals is able to be, so any claim for the National Employment Standards made by someone who believes they were never or are no longer a casual is able to be set off by the loading. That's where our interest is, and that's where the focus is.
And I think the Rosado decision makes that clear, in my opinion, but that's up to you, of course.
How long have you got, do you think?
Probably another two questions, Chair.
Okay, let's go, and then I'll go to Labor.
A question for you as a participant in this process, Ms Parker. Is the industrial law in this country at the moment too complex? Is it impossible to cover everything and impossible to enforce, impossible to understand? How can an everyday worker who doesn't want to become a lawyer possibly understand what's going on? He relies upon other people to interpret for him or her.
Senator, for the bulk of the workforce who are on awards or agreements, it's relatively simple. They don't have to read the whole award. They don't have to read the whole agreement. They need to obviously understand what they should be getting paid and what their entitlements are. We provide a lot of assistance to people who phone us and ask us what, if they have concerns, then we help them. We have a pay and conditions tool that they can look at and work out what it is they should be paid. There's a lot of information out there to assist workers. And we certainly do that to the best of our ability. There is some complexity in the system, but for an individual worker looking at their own individual entitlements, it should not be that complicated. Obviously, if you look at the whole Fair Work Act and say how large it is, you'll say it's really complicated, but most people don't need to look at the whole Fair Work Act. They only need to look at a small component of it.
Well, Mr Turner,
so certainly...
Mr Turner impresses me as being quite intelligent, very, very capable, very astute, as does Stuart Bonds, who's tried to help him with this issue for now 16, 17, 18 months. And they just can't get through it. And I don't think it's a matter of the complexity by itself. It's a matter of the complexity of all the hangers-on that they're trying to drag with them, trying to shake some sense into. There's something in this mess that's causing these people to be discarded, exploited. First of all, a company like Chandler McLeod can exploit them. The Hunter Valley division of the CFMEU enables that, and BHP gets away scot-free and avoids its corporate and moral responsibilities. These people are tossed on the scrap heap. And so there's something wrong with this system. The whole system is broken down.
So, Senator, this is clearly a complex case. It's clearly a complex award and a complex enterprise agreement. Our role is to try to make it as simple as we can, but we can't change what the agreement actually says. It was negotiated, it was approved, it therefore is in play.
So after 6 years, the Fair Work Commission, the Fair Work Ombudsman, the Attorney General's predecessors, it's still here. So I think we've done this enough for now, but this is, you know where I stand. Thank you, Chair.